Hey everyone, Eric Rodebois. So I want to do a little bit of a deep dive on employment contracts. Now this is an evolving art and an evolving science. Here in Florida, we have a brand new law, the Florida Choice Act, which went into effect on July 1st, 2025, that really enhanced the ability of employers to have non-competes and restrictive covenants in general in their contracts with their employees. Now, I've already done some videos about that, so I'm not going to do a deeper dive specifically on that topic today. What I want to talk about is the evolution of the relationship between the potential employee, then when they become an employee, then ultimately they become an ex-employee. And what happens all the time is the ex-employee comes to me and says, "Hey, Eric, am I entitled to a severance?" So let's just start from the beginning. Under Florida law, and I can't think of any state in the United States where there is a law that entitles an employee to a severance. And remember, a severance is usually an amount of money that you would be paid after you're terminated or after your employment is ended. And so a lot of times it'll come up in only one of two circumstances, okay? The first circumstance is where you actually have some power and some control, and that is when you're negotiating the job before or at the very beginning, right? And so you're looking for a position, you get offered a position. If the employer is sophisticated, which hopefully they are, they're gonna ask you to sign some paperwork. Maybe it'll be an offer letter, and maybe there will be an attached actual formal contract. Could be 10, 15 pages. It could have restrictive covenants that you might need to educate yourself on, which are the non-compete, non-solicitation, non-interference, non-circumvention, non-disparagement, non-disclosure, right? And so all the nons. And so obviously this contract can be very important and it can be very binding. If you don't know what you're signing and then you find out later on that you just agreed that you won't compete in that same industry for 5 years, that could really affect your ability to work and live and make money, and maybe people even have to move because they have to move outside the geographic region of the non-compete, just as an example. Well, one upside that you can negotiate is what we call the severance, which could be based on some sort of math formula. So for example, for every year you work at the company, you earn an additional month. I'm just making up math, but it could say something like that. So if I work somewhere 5 years and then they want to terminate me, they have to pay me 5-month severance. But that would be in my contract, right? So 5 years later, when you call the lawyer and the lawyer says, "Well, did you sign an agreement?" Which, by the way, quick side note on that. If you want to have a copy of that agreement, you need to remember to keep the copy in the beginning, because under Florida law, the employer has no obligation to give you a copy of your contract once you sign it and hand it over to them. It's just considered a business record and it belongs to the employer. So if you are savvy, what you do is when you get that offer, you make sure to download a copy, you save it somewhere on your personal computer or wherever you keep your files. And so later on, 5 years later, when maybe you're thinking about quitting or you've just been terminated, and you want to make sure you go back and look at that contract, that you have it handy. I can't tell you how many times people are like, "Oh, I forgot to save it, I don't know where it is," and then the employer can just not cooperate, and you say, "Hey, employer, can I please have a copy of my contract?" And they can say no. Now, other states are different. I'm certain that in California, you have a right to your copy of your contract anytime you want it, forever. And so that it could be state specific. This is why it's important to have a lawyer in your jurisdiction who is familiar with the laws where you live and work. And so you have the contract. Hopefully that's when you can negotiate the severance. Now, what if you don't have it in that contract? Well, then I'll say, well, are there perhaps a policy and procedure, or is there perhaps an employee handbook, and it might include the right to a severance as just a company policy? Maybe. And so I'll ask for copies of these documents. And then lastly, sometimes the company will negotiate and offer a severance, even though technically they don't have to, right? Because the law doesn't require them to. And if it's not in that contract from the beginning, then the contract that they have with the employee doesn't require them to do it. But sometimes, and I'll even be counseling my clients, I'll say, "Listen, why don't you offer this person 1 month severance?" Which, it's not a lot, but it's at least a little bit to get them off their feet. And so that offer could sound something like this. Here's an offer of 1 month severance in exchange for you signing a separation, settlement, and release agreement where the consideration is me paying you money, and in exchange, you agree in writing that you'll never sue the company. You waive your right to sue for discrimination. You waive your right to sue for any other reason that you might be able to sue. And so before you sign that document, of course, you need to go see a lawyer to make sure you understand what rights So maybe they're buying you, maybe they offer you $10,000, but in exchange, you might be losing the right to sue them for millions of dollars, just as an example. All right, guys, well, there's a lot to unpack here, so please leave a comment, give me a call, shoot me an email. I'm happy to jump and answer any questions you have. Thanks, everyone.